Do you like soccer? Have you heard of Inter? I'm Andrei Mincov, the founder of Trademark Factory, and in this video I'm going to share my thoughts about yet another trademarking screw-up. This time around, it's the trademark opposition against the trademark by Inter Soccer Club, the Italian one, by the Major League Soccer Club. Let's do this. So I'm going to start by reading from the article. You can find the link in the description below. I'm also going to comment on the actual opposition paper to give you a little bit more insight into what's going on here. Okay, let's do this. Inter Milan fights back against MLS attack on its Inter trademark application. On March 25th, Major League Soccer filed a trademark opposition against FC Internazionale Milano SPA, more commonly known as international soccer powerhouse Inter Milan. MLS intended to block the registration of Inter Milan's trademark application for Inter. It mainly claimed that Inter is short for international and commonly used to describe soccer teams. It said that Inter has not become distinctive as used on or in connection with Inter Milan's goods and services in the United States. Now, this is important because trademark registrations and trademark oppositions are done on a per country basis. So when you're claiming that you're well known in a country for a certain trademark, you have to be well known in that country. Just because you're internationally well known in, mostly in Europe and all those in those countries that really follow soccer does not necessarily mean that you're well known in the US. So this is going to be one of the points of contention here. So let me keep going. Inter Milan will not simply fold. On May 6th, it filed a partial motion to dismiss the notice of opposition for failure to state a claim. It seeks to remove MLS's argument that the registration of Inter should be denied based on the ground of a likelihood of confusion. Inter Milan says that MLS cannot allege that it owns prior trademark rights in any mark incorporating Inter. So here's what this means. Inter says, if you're saying that our application should be denied based on likelihood of confusion, you have to prove that you have a brand with which Inter, our trademark, will be confusingly similar. And you have to prove that you've established your right before Inter filed their own application. So let me keep going. While MLS filed an intent to use trademark application with the USPTO on September 25th, 2018, that should play no role, says Inter Milan. It filed its own intent to use application for Inter on March 18th, 2014. So interesting. The Italian club also filed based on intent to use. They didn't file based on use since I don't know how long. They said it's an intent to use application. And what they're saying is that the new application that MLS filed does not precede theirs, and so that could not be used to prove likelihood of confusion because a later application, the confusion with a later application is not good enough. As such, Inter Milan says it is clear that it has priority. Additionally, Inter Milan claims that MLS's attempt to establish common law rights attached to Inter Miami FC is futile. Nowhere in the notice of opposition, however, does opposer allege or set forth facts even suggesting that either mark confers upon opposer prior trademark rights that it can assert against applicant, stated Inter Milan in its filing. In particular, nowhere does opposer allege that it used or sought to register any mark prior to March 18, 2014, when applicant filed its Inter application. Opposer has thus not sufficiently alleged prior trademark rights, and Inter Milan separately filed an answer to the opposition submitted by MLS. In it, Inter Milan says that the Intermark is inherently distinctive of the goods and services in the application, and in the alternative, it claims the mark has acquired distinctiveness in connection with its goods or services. So now, here's what this last piece means before I actually go to their opposition filing. When they say the mark is distinctive on its own, they say they don't have to prove that the mark acquired secondary meaning. They don't have to prove that it's known to a significant number of people. All they say is that the mark by itself should be registrable. And they say in case it isn't, well, we have established that we're known to enough people here. The question though is, if they're so well known, why is it that they filed based on intent to use? So that would be an interesting counter argument that MLS can come up with. So let's keep going. So here is the petition for throwing away the opposition. So let's quickly go through this, and I'm not going to go through all the little details, but this is a very good lesson here. Actually, two good lessons. The first good lesson is that when you're dealing with issues like this, with oppositions, with litigation, it's not always about who's right and who is wrong. Many times, the outcome relies on who knows the process better. So what Inter Milan here is doing here is they're saying, it doesn't matter what you say, the way you pleaded it is wrong. And so we are asking USPTO to throw out half of your opposition. So we'll see how that goes, but let me quickly go through the law that they're citing, which is the second lesson. So here's what they say. They say, priority is a threshold issue that must be properly pleaded and proven by any trademark owner opposing the registration of a mark on the ground of a likelihood of confusion. They say, opposer has not and cannot allege that it owns prior trademark rights in any mark consisting of or incorporating Inter. Yet, in paragraph 21 of its notice of opposition, opposer inexplicably seeks to oppose applicant's intent to use based application for the Inter mark on the ground of a likelihood of confusion. The board should dismiss opposer's section 2D claim as facially defective and fatally flawed. So what they're saying is the way they pleaded it is not good enough. And because of this procedural deficiency, that should be thrown out. Here's what they say. They say the allegations in a notice of opposition must include enough detail to give the defendant fair notice of the basis for each claim. A party must allege sufficient facts beyond naked assertions devoid of further factual enhancement to support its claims. A plaintiff must allege well-pleaded factual matter and more than threadbare recitals of the elements of a cause of action supported by mere conclusory statements to state a claim plausible on its face. The board may consider certain objective, verifiable facts available from office records under a motion to dismiss, such as the filing date, filing basis, priority date, publication date, and applicant's name in an application that is the subject of an opposing proceeding. These are facts not subject to proof, and the board may look to office records for such facts to determine if a party's allegations are well pleaded. So here's what they say in an argument. They say a party that has filed an intent to use application may rely on the filing date of its application to establish priority. Okay? And then they say applicant may therefore claim priority back to the March 18th, 2014 date on which it filed the intent to use Inter application. They say, this is when we filed our application, that's the date you're looking for. And then they say, in support of its notice of opposition, opposer relies on its own application for Club Internacional de Football Miami MMXX. Okay. However, it filed the application based on an intent to use on September 25th, 2018, 2.5 years after applicant filed its Inter application. In addition, is it 2.5? So they filed in, hang on. They filed March 18th, 2014, and these guys filed September 25th, 2018. How is it 2.5 years? If my math is correct, then 8 minus 4 is 4 years. So it'd be 4.5 years. So anyway, they say 2.5 years after applicant filed its Inter application. In addition, opposer relies on its alleged common law rights arising from the alleged trademark use of the phrase Inter Miami FC in connection with goods, including but not limited to scarves in class 25. Nowhere in the notice of opposition, however, does opposer allege or set forth facts even suggesting that either mark confers upon opposer prior trademark rights that it can assert against applicant. In particular, nowhere does opposer allege that it used or sought to register any mark prior to March 18, 2014, when applicant filed its Inter application. Opposer has thus not sufficiently alleged prior trademark rights. So what the lawyers for the Italian Inter are saying is that, okay, you say that it's confusing. You say you may have been selling scarves that said Inter Miami FC. Okay, but you're not saying when you started selling them. And because you haven't said that, there's no way for us to rebut that argument. And because we can't do it, what that means is that you have improperly pleaded this part of your notice of opposition, and that's why they're asking to throw it out. And so what they say is, in view thereof, and in light of the strict pleading standards imposed by, some cases, the board should dismiss opposer's 2D ground from the notice of opposition. Okay, this is very interesting because it really boils down to several things. The first thing is, will the opposition board want to look into the process more than it would want to look into the ultimate outcome of the case? And if they're going to look at the process, I think the Italians have a pretty good argument here by saying that, look, if you wanted to claim that you had been using this brand prior to 2014 when we filed our trademark, you should have done so. And because you haven't, tough luck. On the other hand, the opposition board may come up with some sort of interpretation that a prior right was implied, but even if it was implied, you still don't have a date, so you still can't argue with that. So I think it's a pretty good argument that Inter has. Now, what it really will boil down to is how well known is Inter Milan as Inter, how well known are they in the US, right? Because if they can establish that to the relevant audience, the word Inter means that particular club from Milan, I think they got a winner. And if they can't, then there'll be an interesting case to watch. But opposition is more than, oh, I wish I had that trademark, so please don't give it to them. You actually have to establish that your rights, your legal rights, not your wants, not your dreams, not your, I should have done it before. That is the purpose of opposition, to allow you to raise your hand and say, please don't give it to them. And luckily, the Italian soccer clubs got enough resources to throw into this. Because unfortunately what happens many times is that a perfectly registrable application goes through the trademark process, the trademarks office, they approve it, they publish it for opposition purposes, and then somebody bullies the applicant into giving up the trademark. They say, well, we're gonna drag you through the opposition proceedings. It's gonna cost you a lot of money, which many applicants don't have, because opposition proceedings can easily be $5,000, $10,000, $20,000, especially if it goes all the way, to the hearing, all the way to the arguments. If it goes there, it's gonna cost a lot of money, and many applicants don't wanna deal with that. So they give up perfectly registrable trademarks. We've had several clients like that. But luckily, less than 1% of all oppositions get opposed, and most of them get opposed for a reason. So this is another reason why you need to do a proper trademark search before you file your trademark. But again, those things happen. So in this case, going back to my point, Inter has got enough resources to fight it all the way. They probably won't even notice it. So if this goes all the way, it will be a very interesting case to watch. And once we have an update, I'll share that with you. Now, if you found this video useful, if you found it interesting, make sure to subscribe and get notified whenever the next video goes live. And if you've got a brand that you want to protect, whether you like soccer or you hate soccer, maybe you don't like sports at all, then what matters is that you have a brand that you want to protect. And if that's you, go to trademarkfactory.com and book a free call with our strategy advisors, and we'll take it from there. Until then, I'll see you in the next video.